And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for another program of The Law and You. Your opportunity to get free legal advice between now and 9:30. All we ask you to do is get on that telephone as soon as you possibly can. The number, of course, 55208888. That number again, 55208888. And as you probably noticed, a little bit croaky this morning. My apologies for that, but hopefully the voice will hold up to get us through the program. But if you can call in, that would be very useful, because by you calling in with those questions or queries, it means that I don't have to talk as much during the program. So those calls will be greatly appreciated. 55208888. And of course, don't forget our email, talkback@4crb.com, if you have a question or a query and you're not able to get through by calling at the time when the program's on. You can also always send those questions through to talkback@4crb.com. Thank you to all of the people who called in last week to make for such an interesting program. We in fact had, I think, about 8 callers, through a couple of which I had to take off air after the program finished, because time simply didn't permit those calls to be taken on air. But one of those, which was quite useful, was from Peter, who rang in relation to the query that Barry had raised earlier in the program. Now, you may remember that Barry was 88 years of age, and he'd suffered a bleeding nose as a result of medication, and he passed out for 5 or 6 minutes, and as a result of that, his doctor wouldn't issue him with the appropriate certificate, medical certificate, to renew his licence, and so he now has to wait until he'll be able to get his licence again. Peter pointed out that between 75 and 85, you must get a medical certificate each year. So if you're going to be renewing your licence after you're 75, a medical certificate is required. However, once you get to 85, you've got to do a test each year in addition to the medical certificate. So, Barry, if you happen to be listening in this morning, hopefully that's a little bit of information that will assist you. But we're waiting for those callers. You could actually be our first caller online if you call now, 55208888. We, of course, had a bit of a delay in calls coming through last week, and then an avalanche of calls in about the last 15 minutes of the program. So if we can space those out during the program, that would be greatly appreciated. 55208888 is the number. We'll be back after this word from our sponsor.
Are you serious about losing weight? Vitadiet has been helping Australians lose weight and live healthier since 1987. All Vitadiet shakes, soups, bars and desserts are gluten-free, made in Australia, and have been perfected over 30 years. There is a Vitadiet eating plan, and yes, you do eat real food. Plus, use the Vitadiet ketone sticks to gauge your fat-burning performance. To find out how you could lose up to 3 kilos in your first week, visit vitadiet.com.au for your local pharmacy or call 1300 Shakes. Vitadiet. Time to try it?
Our sponsor.
Air conditioning installation from just $499 at Harvey Norman. Limited time only. Great deals on Fujitsu, Mitsubishi Electric, Kelvinator and Rinnai, plus 18 months interest free. Yes, a new split system air conditioner plus installation, all with no deposit, no interest and no payments for 18 months. Approved applicants only. Minimum financed amount $500. Interest applies if you do not comply with terms and conditions. Fees and exclusions apply. See website for details. Standard installation only. Air conditioning installation from just $499 at Harvey Norman.
Another sponsor.
Oh, that sponsorship announcement, of course, reminds me that it's only 106 days until Christmas. Can you believe that? 106 days. My goodness, fast approaching. But enough of that. We have our first caller online, as we say a very good morning to Barbara. G'day, Barbara. How are you today?
Good morning. I have been better, but I'm feeling a little bit better today. Thank you.
That's good.
I've got a problem with revoking a will and making a new one, but in that original will, or done by the same solicitor, is the power of attorney. Now, if I made a new will, I would also have to make a new power of attorney, wouldn't I?
Firstly, the power of attorney is not contained within the will. A will and a power of attorney are two entirely different documents.
That's right.
I think what you may be saying or may be thinking about is, have you appointed the lawyer as your executor, have you, and also as your attorney?
One of
Right.
Yes.
Okay. So if you're thinking of removing the lawyer as the executor in your will, then you can do that simply by doing a codicil to the will. If the terms of the will are otherwise as you want them to be, but you simply don't want that lawyer to be the executor any longer, then you can simply do an executor which will amend that clause in the will, which will remove that person as executor and insert whoever the new executor is going to be, or alternatively, if there are already two...
there are other executors.
Yeah, well, if you have other executors, then you would simply be removing that one particular person. Now, unfortunately, with the power of attorney, you can't do that. What I would be recommending you do is to prepare a new power of attorney, which will appoint whoever the new attorneys are that you wish to have.
I would have thought that. Thank you very much for affirming that. Thanks very much. Yes, I'm understanding what you're saying.
All right.
All right. That's big help. Thanks very much.
Okay, Barbara, no trouble at all.
Thank you. Goodbye.
The Law and You is the program. 55208888 is the number. If you have a question or a query, get on that telephone straight away. The lines are still free, so you can get straight through. You may remember last week that I was talking about all of the press surrounding purchasing off the plan, and in particular as a result of the collapse of the Raylan Group, and also all of the issues surrounding the use of cladding materials in relation to certain buildings, and I did make comment on the fact that over my career, which included 30 years of dealing in property and commercial matters, I certainly never saw a problem with a building where there was a purchase off the plan. But there are a few things that I think it is useful to bear in mind when you're looking to purchase off the plan. Firstly, you're certainly quite entitled to ask the developer what sort of materials they're going to be using for the finishes on the building, and to assure yourself that the finishes on the building are not going to present the sort of problems that came up. Things like concrete cancer and problems with structural problems, of course, are a little more difficult to identify. But I think the way around that, or the best thing that you can do to try and minimise the likelihood of any problems in that regard, is to deal with developers and in particular builders who have a very long and good record in the construction industry. So there are obviously a number of developers around who've been building high-rise developments for a long period of time, and there are all equally quite a large number of very highly regarded construction companies that are building. And so I think if you look to the materials that are being used, if you ask for, you wouldn't be able to get the total specification for a building, but I think you would certainly be entitled to ask questions that are going to answer those queries for you. Then hopefully that should minimise to a certain extent any risk or concerns that you may have. One of the other areas is, of course, the deposit, and I was absolutely horrified to hear that in the Raylan Group matter that people had agreed to release their deposits on an interest-bearing loan to the developer. Now, deposits, when they're paid in off-the-plan transactions, are required to be held in trust, either in an agent's trust account, a registered real estate agent's trust account, or alternatively in the solicitor's trust account. Now, obviously, what Raylan were looking to do there was to circumvent those requirements by putting in place this loan arrangement where the deposit was actually loaned to the developer, and of course, this came on the promise of a very high interest rate. that was going to be paid comparatively to what interest rates are at the moment. I think from memory I heard one of the reports on the news suggesting that that those loans attracted interest of 10%, with the interest to be paid at settlement. Now, so it comes back to that old thing that if something sounds too good to be true, it probably is. And 10%, of course, is a very high interest rate in the current interest environment. And so one must only ask, why would the developer be looking to have that money released? And be offering such a high interest rate, because the higher the interest rate, of course, the higher the risk. And so they're the things that people need to bear in mind. But enough of that. We've got another caller online, as we say a very good morning to Ted. G'day, Ted. How are you today?
Good, thank you, John. I have a general question about body corporate dealings with the duplex. I've owned a duplex for about 18 years and kept the body corporate going that the developer set up just between the neighbour and myself. And I'm now selling my side, and I'm just wondering what the legalities are about not having the body corporate meetings, etc. I know a lot of people just share the insurance and water, etc., and don't bother with the body corporate. I would like to pass it on to the new owner, but what is the legal situation in regarding duplexes?
Right. Well, Ted, my understanding is that there is provision for what are referred to as small body corporates. And a duplex obviously would be about the smallest body corporate you could have. And it's my understanding that if there is an agreement reached between the parties, that they will basically each be responsible for the maintenance of their particular unit in the development, and secondly that they will agree each year to pay the insurance, then that is satisfactory. But what I would suggest you do in relation to that would be just to give a call to the office of the Body Corporate Commissioner. Have you got a pen handy? I'll give you their number.
No, I don't. I'm afraid I'm in the car. But,
right,
I
okay.
can look it up.
Well, look, if you just look up online, you're in Queensland, are you?
Just south of the border in Tweed.
Oh, right, okay. Well, look, that would come under the New South Wales body corporate laws rather than Queensland. So you'll have to take a look. If you've got a computer and you can take a look online, you should be able to find their details on the computer. Or alternatively, if you rang the New South Wales Law Society and just asked them for the number for the particular department of government in New South Wales that looks after bodies corporate, you could give them a call and I'm sure they'd be able to help.
Well, you're very, very helpful. Thank you very much, John.
Okay then, Ted. All the very best.
Thank you. Bye-bye.
And the time on 4CRB is just past 19 minutes past 9. The $64 question is, will the voice last until 9:30? But we're still getting there, and we say a very good morning to Paul, who's online. Good morning, Paul. How are you?
Hello, John.
Yes, Paul. How are you?
Good, very good. A bit bloody fresh down here at bloody Eleanor, I'll tell you that.
It's a bit fresh everywhere this morning. I noticed as I came out of the house and put the garage door up, it was certainly a cold breeze.
Oh, well, I tell you what, I run a company, John, called JFK, very popular bloke back in the 60s.
Yes, I remember him well.
Yeah, I remember him well. It's a kitchen business, kitchen bathroom business. Affiliated with another company, AASC. We got approached now for the amount of work we got tied up with a company called Pace Universal.
It'd be better if you don't name any organisations, if you don't mind, Paul. If you just tell me what your problem is.
Well, the problem is working on a share basis on the quality of the amount of work they bring in back into my company on a 70-30 basis, or or vice versa, 65-45, to being up like a contract on jobs at so much price for them type of two arrangements type of thing, you know, and they're not willing to buy the company name yet, but to take over some of the big jobs we've got. So on those bases of a 70-30 and a 70-45, or 75-45. Now on the contracts, on those arrangements, have you heard of anything on that arrangement? Is that feasible? It should be, shouldn't it?
Well, I mean, people often will enter into what are referred to as joint venture arrangements for the supply and development of particular products. And the most important thing in all of these arrangements, Paul, is to make sure that you have clearly documented whose responsibility is what, what the cost sharing and the profit sharing arrangements might be. But the other really important thing in these things is to have very clearly demonstrated in there what happens if something goes wrong, because that's when it always becomes a real problem.
Yes. And saying that, John, doing a search on these this Pace University.
No. Look, I've said please do not name any organisations.
No, I'll block that out. But I'll just say doing a search on them, I will know more by next week.
Yes.
On their capabilities and their liabilities and what they've been and what they've done.
Yes.
So, okay, yeah.
But what I would recommend you do, Paul, the very first thing I would recommend you do is get in touch with your solicitor and go through the whole deal with them. Whatever you do, don't just simply rely on doing a deal on a handshake or doing a deal on the back of an envelope, because they are invariably the arrangements that lead to heartache. So if you have a very clear understanding of what the deal is at the start, you very clearly document what the deal is, so that both parties or all parties to the transaction understand what their obligations are in terms of the arrangement, what the expectations are, how the costs are going to be shared, how the profit is going to be shared, and most importantly, what happens if something goes wrong. What's the process for mediation or arbitration or conciliation, whatever, to resolve any problem that may arise down the track?
Yes.
So
okay, John,
number one, see your solicitor, Paul. That's the very first thing to do. And invariably, it'll cost a bit of money to put the arrangements in place. But it's one of those things, Paul, as they say, marry in haste, repent at leisure. So I would strongly recommend that you get the documentation right at the start. Spend that little bit of money up front to make sure you've got it right, rather than spending a fortune with a lawyer at a later stage when it's all gone pear-shaped and it's all becomes he said, she said, and it will just be an absolute disaster in the courts. So get it right from the start.
How it feels to me at the moment, John, they're trying to pick up after 15 years establishing these two businesses on my name type of thing, and to bleed off my initials of my company name. But that's very good, John. Yes, I do know that with the National Bank, who gave that confirmation yesterday, but I'm glad I've talked to you.
Yep.
Okay,
as I say, make sure you get legal advice on it, Paul. That's the best thing you can do. All right, then.
Okay.
All the very best. Time on 4CRB is just coming up to 25 minutes past 9. We'll be back after this word from our sponsor.
Thousands of abandoned and homeless animals depend on Animal Welfare League Queensland for help every year. Their doors are always open to them, and with your support they always will be. Leaving a gift in your will to Animal Welfare League Queensland will create a lasting legacy and is a touching way to make your love and passion for animals live on for generations to come. Visit our sponsor's website awlqld.com.au or call 550 099.
If you're retired or coming up to retirement, you should speak to Independent Wealth Management. Founder Tony Walker and the team, including senior financial advisors Linda Griffith and Joe Walsh, have an average of 30 years experience each, helping clients meet their objectives in retirement. Independent Wealth Management is a member of the IFAAA, privately owned family business not owned by a bank or insurance company. Phone 5636 3800. Australian Financial Services Licence 4934. A sponsor.
Well, thank you to all the people who've called in this morning to make for such an interesting program. Only 3 calls, but nonetheless varied, and that's what always makes the program interesting. I do apologise for my voice this morning. I hope it's not been too annoying for those of you listening. And I'll certainly hope that next week when I'm back, my voice will have totally recovered and we can get back into the program without those problems. As we don't have any callers online at the moment, we might wrap the program up a little bit early. We'll take a music break, and of course at 9:30 it'll be 4CRB Local News. John Fradgley from the Bell Legal Group. Until next week, goodbye and God bless.